Option agreements can protect writers in the development phase of an entertainment project. Done right, the writer can be confident that their intellectual property, screenplay, or novel will be optioned with terms that are fair. However, there are 3 elements in the option agreement that can make or break a deal. I will show you what to focus on. Option agreements protect producers and writers during the development phase of an entertainment project. The last video in this series focused on what producers should look out for. In this video, I will focus on writers and what they need to focus on. The number one element of an option agreement writers need to pay close attention to are what rights they are reserving. This is usually a clause called reserve rights. If you are a writer, and more specifically a writer or author with clout and leverage, this clause needs to be in your option agreement. You need to explicitly state to the producer what rights you will be granting them and which rights you will be keeping for yourself. Before drafting this clause, the writer and the producer need to agree on if the picture is just going to be a film or a television series, stage play, or podcast. The most common rights to be reserved are: number 1, publication rights; number 2, sequels and prequels; number 3, live stage play rights; number 4, podcast rights. These 4 reserve rights can be very lucrative to writers if the property has a large audience and market. With the boom in podcasting, reserving podcast rights can help writers explore another worthwhile entertainment venture with their property. By having a thorough reserve rights clause, writers can exploit their work in other mediums. The second most important element is the development clause. The language in this clause usually lays out what the producer will be doing with the property during the option period and whether the writer will have any role or approval during the development phase of the picture. Being the writer and creator of the property, you will rightfully be invested in what happens to your work. Therefore, you will probably feel like you deserve to have some say during the development stage of the picture. If drafted correctly, it can definitely help writers carve out an important role and voice on the development of the picture and ensure that the producers are not damaging the artistic integrity of the property. Finally, the third most important element is the sequels and remakes clause. In some instances, once the producer exercises the option and acquires the motion picture rights to the property, the producer may have sequel or remake plans for the picture. Therefore, writers should think about this long-term possibility and have a sequel and remake clause in their option agreement. If written correctly, this clause will give the writer the right to the subsequent picture and at a compensation level hopefully higher than what they were paid for the original picture. Focus on these 3 elements in the option agreement, and as a writer, you will protect your rights today and in the future.